Hi, Lisa. How are you?
I'm good, thank you.
I'm very happy to meet you. This is my first time meeting you, although I've been following you and I've been reading your posts and your writings. You are, I mean, obviously in the criminal law world, everybody knows you, and the Supreme Court has been referring to your work as well. Your area of interest is really a hot topic right now in criminal law, and that's why I'm really very excited to be chatting with you today, especially also that there's a recent Supreme Court case, the case of Senneville, where your work was also extensively quoted in that court, in that decision, sorry. And so we will be talking today about that. I'll let you first introduce yourself for those who don't know you. I know a lot of people know who you are, but for those who don't, uh, introduce yourself in your own words, and then we'll get to talk about so many things that we want to cover today.
Well, thank you, and thank you so much for inviting me. I'm really happy to have this opportunity. So my name is Lisa Kerr, and I'm teaching at Queen's. I've been here since about 2016. I started out in British Columbia. I went to UBC and clerked at the Court of Appeal there, practiced for a few years. I practiced for a period of time at a place called Prisoner Legal Services in BC. And it was a legal aid office dedicated to doing litigation for incarcerated people. That work and that experience really informed a lot of my academic interests. So when I went off to do an LLM and doctorate at NYU, I was really focused on sort of how we regulate prisons, right? How do legal systems govern what goes on the sort of punishment end of the spectrum? And so, yeah, I came from New York City to Queens, and I teach evidence. I teach first year criminal law, and I teach a course on sentencing and prison law. And then one of my real passions here in Kingston is the work of the Queens Prison Law Clinic. So, this is part of the law school. We have our law students working in the clinic, going into the many penitentiaries in the region and assisting incarcerated people with their disciplinary court matters, with parole, with transfers. And we do a lot of strategic litigation as well. So we're, regularly appearing as intervener at the Ontario Court of Appeal and Supreme Court of Canada on issues that we think will affect the clients of the clinic. So yeah, great to join you today.
Well, it's my honor to have you as my guest here today, Lisa. And I know that we originally wanted to talk about other things that we will still cover, but then in between, we had this important case that came out of the Supreme Court. It was on a day before Halloween, on October 30th, or on Halloween, actually, I think that it came out. So only like very recently, the case of Senneville, and it's a very important case for various reasons. But the most important thing is that it really clarified many of the important sentencing principles, especially the principle of proportionality, which in cases of sexual violence, especially against children, it seems like it hasn't been properly applied by the courts. There seems to be a lot of emphasis on the nature of the offenses and how awful they are, and this tendency to want to overpunish when there should be consideration to other uh, principles of sentencing. And I think the court clearly clarified that in Senneville, but there was some backlash to that decision. So I'll let you give us your thoughts, and we'll start from there.
Yeah, there certainly has been a lot of backlash, and even from politicians that we don't necessarily expect it from, right?
Yeah.
There was comments even from Wab Kinew about this case that were pretty shocking to hear. And certainly there was, many more calls to invoke the notwithstanding clause and all of these kind of standard conservative moves now
Yeah.
in the face of this decision. So yeah, maybe we could just start by talking about what the case was about. It was about the 1 year mandatory
Mhm.
for possessing and accessing child pornography. And there were two offenders before the court. And the public, I don't think, understood that one of the sentences had already been corrected by the Quebec Court of Appeal. So one of the sentences, I think, for Mr. Senville was a 90-day intermittent sentence for a fairly large collection of images. And that had already been corrected at the Quebec Court of Appeal, and he did get the 1 year
Yeah.
sentence. Exactly. And their two sentences were not at issue at the Supreme Court of Canada. The Crown was not appealing them any further. So those two individual fact scenarios were not even before the court.
Yeah.
All the court was considering was the hypothetical scenario in which the law could apply. And now this has been the most controversial part
Yeah.
of Section 12 doctrine, no question. And it goes way back. It goes back to the first Section 12 case that we had in 1987, the Smith decision,
Mhm.
right? That was a 7-year mandatory for importing, really hefty one. And the court there was concerned that it would apply no matter what quantity of drug you had, no matter what type of drug, no matter your age, or if you had no criminal record. So the court worried in Smith that you'd have to impose a 7-year sentence on a 19-year-old who brings a single joint over the border.
Yeah.
So the court in Smith didn't use the phrase reasonable hypothetical, but it invented the method, right? Mr. Smith, who was before the court, had like an 8 or 9 year sentence that wasn't being appealed. The issue wasn't the sentence for him. He was kind of a big time drug importer, right?
Hmm.
The issue was who it could apply to. And so in every single mandatory case that we've had in the entire history of Section 12 being part of our constitutional landscape, we have done this. We have thought about how a mandatory could apply. And it's always been seen as very controversial because it's the court, imagining scenarios, right? Or doing some kind of active creative writing instead of just dealing with the adjudication of disputes before the court. And I say, those critiques are really misplaced because what the court is doing is not creative writing, but is just statutory interpretation,
Yeah.
right? Which is a very basic judicial task. And in some cases, it also resembles judicial notice, right? When they're imagining, that an offender might have no criminal record, right? That's just a very common everyday fact that sentencing courts are accustomed to dealing with. The fact that some offenders are very young and have no criminal record, and that is very mitigating in terms of their sentencing. So when we do the reasonable hypothetical analysis, it's really just about looking at the offense and saying, what kind of ground does this offense cover in terms of the act element and the mental element? And then what kind of offender could be caught by it, right?
Right.
Could it be a young Indigenous person with really strong Gladue
And no
factors?
record.
And no record. And none of that is a matter of make believe or creative writing, right? This is really basic, fundamental judicial activity.
And sorry, I sorry to interrupt here
No,
because
no.
I think it's also important to make a distinction. There are different types of courts. Like there's a difference between the Court of Appeal of the province and the Supreme Court that have to like their decisions apply to the entire province or the entire country, as opposed to the local courts that are just deciding the facts before them most of the time. So when the Supreme Court is going to render a decision, like I feel like they have an obligation to consider other situations because it's not just for that case. Their decision is going to potentially apply to cases in general at large and everywhere. So that's why I feel like there has to be some consideration as to the level of court that we're dealing with. And that's why when we're dealing with the Supreme Court, we want them to take into account not just the case before the court, because whatever they decide has to apply to everything else that's similar to that case.
Yeah, I think you're right to say we're really talking about the court doing what is essential to the judicial
Yeah.
function, at least in our constitutional
Hmm.
setup,
Yeah.
right? Going back to Big M Drug Mart, right? The
Yeah.
court has said, what is that issue in a charter case is the nature of the law that is before us and that we are being asked to apply. It's not the status of a single
Yeah.
complainant.
Exactly.
And that's the role of the court in the
Hmm.
era of the charter. And so, it's interesting. Various cases have talked about the legitimacy of this approach. And most recently in Hills, Justice Martin went over the reasons why we do this. It's partly a matter of judicial efficiency. We want to address the constitutionality of a mandatory provision, and rather than having a multiplicity of
Yeah.
litigation going up through
Yeah.
the courts all
Yeah.
through the country. And so that's really the court just doing what it has to do in an efficient way. But one of the other justifications that is new in Senneville is talking about the impact of mandatories on the plea bargaining context.
Hmm.
right? And in some cases, there's a mandatory that applies to a more serious version of an offense, right? And a less serious version doesn't have the mandatory. And so in those settings, right, it can really kind of weigh upon the plea context as someone considers, oh, if I agree on the lesser version, then the mandatory might be off the table. And here the court says, given that it may be that mandatory minimums can actually be influencing the outcome of a particular case without ever coming before a judge, right? So in this way, it's insulated from legal review.
Hmm.
It may affect how people who are accused move through the analysis of whether to plead guilty and
Yeah.
so on. And I was happy to see the court address those realities really for the first
Yeah.
time. And I think it's part of why this reasonable hypothetical approach is particularly necessary in the Section 12 context.
Yeah.
I hate to tell this to Canadians because it's already so controversial, but this technique has migrated beyond Section 12. Like it shows up in other kinds of cases as well
Hmm.
now.
Yeah.
And I'll leave it to sort of constitutional scholars to debate the legitimacy of it showing up in other kinds of cases and so on. But in the criminal law context, right, where you have resolution agreements that are often struck in the shadow of criminal code provisions,
Yeah.
it's particularly important that those provisions not be potentially unconstitutional,
Hmm.
right? Because the particular accused may not have an opportunity to challenge them,
Yeah.
yet it has impacted their resolution agreement. And
Yes.
so there's a particular need in the criminal law context to use the hypothetical analysis and to make sure that the laws that are affecting how cases are resolved are all constitutional. So that was just like a piece on the legitimacy of that reasonable hypothetical device. I don't think that my comments are going to bring a close to the controversy. Nothing seems to bring a close to the controversy, but I think I'd just like to firmly say that those, and there's judges who have launched this critique as well, those who would say that this is a matter of creative writing or judicial make-believe, really don't seem to understand the task when it comes to constructing the reasonable hypothetical.
Yeah, and I mean, I think one of the issues that we have with this case is what we've been struggling with since Friesen, and that's why there was also a lot of reaction to this case. It's because it's specifically talking about child pornography, and the problem that we've had since Friesen is that there was a lot of focus on there are certain types of offenses, especially sexual violence ones and the ones against children, that we have to be very harsh with them. It doesn't matter, like the all the other stuff, like the circumstances of the offender, rehabilitation, all of that, that is minor. Like in these cases, it seems like courts and crowns have been interpreting Friesen to stand for the fact that for these types of offenses, it's denunciation and deterrence that we need to focus on, and other stuff goes to the background. We don't really care that much, and that is not true. And for me personally, when I was reading Senneville, that was one of the things that I felt the court was really trying to emphasize. I think they said that also at paragraph 97, where they were saying that like the argument of the appellants is just like focusing exclusively on the offense, but not on other factors. But those factors are still relevant. Proportionality still applies even in these cases. And I find that the criticism to this case also comes from this attitude of, well, it's child pornography. How can you say that about, child pornography? We need to focus on punishment. I don't know. What are your thoughts about that, Lisa?
Yeah, so I always think of Friesen as a really important case that
Hmm.
corrected a long history
Yeah,
we had of really failing to properly understand the harm of sexual abuse against
right.
children, right? And it was an incredibly important corrective. There were so many things wrong with how both society and the legal system handled and perceived the wrongs that committed against children.
Yeah.
And so much of Friesen is incredibly important for
Yeah.
that reason. But you're absolutely right to say Friesen does not alter the fundamental architecture of
Mhm.
sentencing law in
Yeah.
Canada. And that architecture is one where, yes, there can be very important purposes like deterrence and denunciation, in particular, offense contexts. And no doubt, sex offending against children is one of those
Yes.
contexts. But the every sentence that is imposed has to be fit, right? And deterrence and denunciation are not a trump on fitness. And that concept of proportionality or fitness is about not just gravity of the offense, but also circumstances of the offender. And, circumstances of the offender, this is an area that has, developed in extraordinary ways in recent years in Canada. We have a very open approach to what qualifies as a collateral consequence,
Hmm.
right? Very broad in cases like FAM and Souter, and in
Yeah.
Ontario, many cases from the Chief Justice
Yeah.
Tillett that have built on that, the impact of custody on young people, the impact of custody on people with mental health issues, family separation, all of that remains sort of in the ledger of what is going to be a fit sentence. We also have, a kind of subset of collateral consequences, a lot of willingness from the Supreme Court of Canada to look at the impact of incarceration as part of sentencing,
Yeah.
right? And really, I think rejecting an older formalism in which sentencing judges understood their role to be simply about kind of a backward-looking tallying of the offense and the offender, right?
Hmm.
And I don't really care that much about what the sentence is going to look like going forward. My job is to just put a number on
Yeah.
on the wrong. And Justice Martin and Hills and Hillback and other cases has said, that sentencing is about more than just quantification, right? That the experience, the impact, the effects of incarceration, which vary in extraordinary ways between individuals and between groups and even across prisons, right?
Yeah.
That all, to the extent a sentencing judge is able to think prospectively about those issues, that all is part of sentencing, that's all part of fitness. So
Yes.
that's just all to say, there's no question that the gravity of sex offending against children is not the only factor at sentencing, right? Now, um, but just shifting back to what actually was decided in Senneville, I mean, the reasonable hypothetical that the court was concerned about here, some of us would question whether this is even our mental image of what child pornography is. The fact scenario that the court was concerned with was an 18-year-old who passively receives an image from a friend.
Yeah.
Right. So didn't ask for this image, wasn't part of its creation, but just gets a text on his phone of his friend sharing a photo of like his friend's girlfriend,
Yeah.
who might be, who knows, 15, 16,
Yeah.
17,
Or
um,
13.
or 13,
Yeah.
but whatever it is, let's imagine 17, right? Because that's the sort of that's what the offense could
Yeah.
cover. And that's going to be the most problematic scenario, I think, for the mandatory to apply. Um, if he looks at that image and decides to keep it,
Hmm.
right? And I don't want to say that that's no big deal that he decided to keep it. I would certainly raise my children to immediately delete that, and I hope we all would.
Yeah.
And it is wrong that he did it, and it is technically the commission of this offense.
Yes.
But the fit sentence for that 18-year-old who passively receives the image of a 17-year-old and fails to delete it is, the court says, a conditional discharge.
Hmm.
So something that would convey to this young person how serious it is to keep something like that, but that obviously wouldn't completely send them off track at the beginning of their adult life.
Yes. Yeah.
And so a year in custody, I think many in the public go, well, how could a year in custody ever be grossly disproportionate? How could that ever shock the conscience, right? When we're talking about child pornography. Well, actually, and Pierre Poilievre likes to talk about, as a father, I don't know how. Well, you know what? As a mother of two boys, right? I also imagine that my son could commit that offense, right?
Yeah.
It's not only that our children are victimized, it's that our children can also make mistakes.
Yeah.
And the court talked about, that this is not a far-fetched or remote possibility. Teenagers all have phones. They all share images and take images all day long. I'm saying this as though adults don't do that. I mean, we all do that, right?
Yeah.
But teenagers do it with a little less judgment,
Yes.
right, in hand. And this could easily occur, right? And
And
you
they
know,
do it, sorry, sometimes not realizing that this is child pornography. Like that's the problem with younger offenders. They don't realize because they're dealing with people who are their age, who could be, like you said, a girlfriend or a friend. So they're not thinking that the picture, the compromising picture of
right.
this young girl is child pornography. So
Well, and we are in a time where we need to, learn more about that and
yeah,
fold it into our parenting and so
yeah,
on. It is a version of this offense. And I mean, so some might say in response to that, no crown is going to charge this in a way that would attract the mandatory. And, I hope that's true. And I trust it is true. And I think it is, accurate that most crowns would not be interested in that. But as you know, the law on this, that argument was part of the dissent in Kerr, the idea that where it's a hybrid offense, we can just trust Crown prosecutors, is with Justice Moldaver's view. Or was it Lloyd? Anyways, it was one of those
yeah,
where Justice Moldaver said with a hybrid offense, we don't have to worry about this so much because responsible crowns, we can assume that crowns act in the public interest and for that really, really mitigating version of the offense and the offender, then they'll deal with it in another way. And that is, I think, a very sensible argument, and I think it is largely true. But the Supreme Court of Canada explicitly rejected that and said
hmm
relying on the discretion
yeah,
of state
yeah,
actors
yeah,
is not a cure for an
yeah,
unconstitutional provision.
yeah.
So that argument has been disposed of, right? That is not a way to save these provisions. Um, so yeah, I think that kind of covers it. You know what I noticed in a few days, like the first few days of public reaction to Senneville were pretty brutal. And then I was joking that Andrew Coyne wins the read the whole decision award because, within a few days, Andrew Coyne wrote a piece that showed that like he had actually kind of absorbed all of
Yeah.
it,
Yeah.
which the first few pundits and commentators didn't
Yeah.
seem to have like fully read and absorbed that, this wasn't about the 90-day sentence that the Quebec Court of Appeal had already corrected and
Yeah.
found to be demonstrably unfit. And then people started, there are a few pieces out there around the fact that Parliament can draft a provision that would have a presumptive sentence, I should say, a
Yeah.
presumptive sentence for the offense of possession. It just needs like an escape hatch, a safety valve, something that would allow judges the ability to not apply the provision in a case where it would be grossly disproportionate.
Yes.
So that option is there, and I was happy to see it from the liberal, government reaction. It seems like that's the path that they're planning to take.
Well, I mean, I really hope that people will, like you said, take the time to actually read the decision. From my perspective, the way I saw it is that it was just really clarifying the basic principles of sentencing. Like, there's nothing drastically new in this decision. It's just a clarification because for so long, since Friesen at least, which is from 2020, I just feel like there were some misinterpretations of that decision and the
Yeah.
proportionality principle. So it's not a radical decision. It's
You know
just,
what? Can I say there is
yeah,
something radical in this decision?
yeah.
And
Okay.
it's in the dissent.
Yeah, sure.
So
Thank God, but it's not the law.
that's right. But I do kind of want to pause on the dissent
Yeah,
for a
go
moment,
ahead.
if you don't
Yeah,
mind.
no problem.
Just because, when I saw that when I picked up this decision and I clicked on it,
Yeah.
I thought, oh, a dissent, interesting. And, my mind, our lawyer minds immediately went like, oh, like I know the various moves that could occur in this case for there to be a dissent. I wonder which path they took.
Yeah. Yeah.
As I read it, it was a page turner for me
hmm
because they didn't take those paths. They took
hmm
a completely unexpected one. And it was very surprising to me that this idea in the dissent that the reasonable hypothetical scenario actually has to be factually similar to the case of the offenders before the court.
Yeah.
This is the dissent. This is a completely new idea that has not been part of the law in any of those cases going back to 1987.
Yeah.
And so it was a real surprise. And the court or the dissent does it by retranslating some of the French in Goltz, right? And saying that the word remote actually means this and that. And so there's this like some intellectual kind of fancy footwork happening there. But I thought, well, this is definitely not the law because the entire reason that the reasonable hypothetical methodology is controversial, and it is because it is not factually similar,
It
right?
contemplates like a
It
big
contemplates
basket
whole other
of,
scenarios.
yeah, exactly. Because, like you
Exactly.
said, not every case is going to go up to the Supreme Court. And we don't want that. We don't want all these cases to go
Right.
up to the higher courts. We want something that is clear from up and
Right.
that we know how to apply on a daily basis in the trial courts. So it has to take into account not just what's directly before the court, but also in general. And that's why we have a Supreme Court. Otherwise, like we can just stay at the trial level. But every court has a different scope or a different, let's say, angle of seeing things. And the Supreme Court has the biggest angle because or the widest one, because it has to cover the entire country, any
Mhm.
kind of other situation that can come up that's kind of similar. And we don't want, again, we don't want to have a Supreme Court that also has a backlog. Like,
Right.
unfortunately, what we have at the trial level, where we
Right.
have so many cases, we do some of them don't even get reached. So we don't want this to happen at the Supreme Court level, where we have tons of cases that could have been dealt with just one, reasonable hypothetical.
Well, and they only hear about 40 or 50 cases a year,
Yeah,
so there's lots
exactly.
of time
Exactly.
to thoroughly explore. So yeah, that part of the dissent was really, really striking.
Yeah.
I know it's not the law, but I just, it's a 5-4 case. It was darn close.
I agree. I agree.
And
That's scary.
I if you wonder to yourself, why would I mean, Justice Cote is very consistent in this area. She dissents on all of these. So and Justice O'Bonsawin, this was, I think, her first big Section 12 case that she was on. And so,
Mhm.
but we really see, I think, a significant and just the Chief Justice dissented in cases like Nur and so on, but he was in the majority in Hills. And so there's a real vote switch, I think, between him and Justice Rowe in this particular case
Hmm.
from Hills.
Yeah.
And that this requirement that the case before the court be factually similar to the offender's case before the court, it's totally absent in Hills and Hillback and Bertrand Marchand. Like
Yeah.
it's nobody thought that was how it is. And if you kind of wonder, well, why would the Chief Justice do this? He kind of gives it away at one point and says that the public confidence in the administration of justice really requires there to be a closer connection between the hypothetical and the case before the court. So I think he's there kind of acknowledging he thinks the ongoing controversy and contested nature of the hypothetical methodology is bringing a cost
Yeah.
um, to the legitimacy of the court. And he may be right about that. There's no question that the controversy never seems to die down,
Hmm.
even though it's how we've adjudicated every single case
Yeah.
in the charter era
Yeah.
at the Supreme Court. And
Yeah.
some have won and some have lost. Some provisions have been upheld and some have been struck
Yeah.
down. It's not a sort of simple story there. But there seems to be a view that like we should give it up because the controversy won't settle down. And so I think that is what motivates his decision. It's not a retranslation of some of the French in a decision from 20 years ago, right?
Yeah.
Like it's a straightforward kind of political call that there's a legitimacy cost here that we should try to address. So anyways, I found that very striking in the dissent.
Yeah. No, it
Yeah.
was really it's a very interesting decision. I find like to me right now it's one of my favorite Supreme Court the majority, not the dissent. But it did, like you say, there was a lot of controversy. But let's jump now into another controversy, and that's the Maplehurst controversy, because that was really shocking what we saw in the Toronto Star. I know you've been writing about the conditions in the jails. Like this is one of the areas that you're really very interested in and that you really work a lot um, in this area. This was shocking. It continues to shock courts because we've seen also some recent court decisions where very serious charges have been stayed because of these terrible conditions at the jail. And Maplehurst, unfortunately, seems to have one of the worst reputations right now. Like we're all very nervous when we have clients there because we know it's going to be horrible. So let's
Mm.
talk a little bit about this, Lisa.
Yeah, so I mean, it is a just wild moment in this
Mhm.
space in this
Yeah,
country right
yeah,
now.
yeah,
So just to sort of paint the broader context before getting into the
yeah.
Whitlock decision specifically, we are obviously having a kind of national policy conversation about bail,
Hmm.
and the conversation there is sort of whether to tighten access to pretrial release. And the federal government has made a call that we want to move in that direction, and they've
Yeah,
tabled Bill C-14. And
yeah,
we could have a debate about whether it will really change things or whether it's sort of an exercise in codification and so on. But setting that aside, there's no question there's a policy push, a political push to make bail more difficult to obtain.
yeah, right.
At the same time, at least in the province of Ontario, there is this perpetual state of crisis in the remand facilities. And Maplehurst is the latest and the most serious iteration, but this is not new,
Yeah,
right? This is, I can't even keep track of or hope to read all of the decisions in which sentencing courts are faced with these extraordinary records of lawless, inhumane conditions in the remand facilities as part of sentencing, right? And they have to somehow account for this at
yeah,
sentencing. You can't even keep track of the cases.
yeah,
It's like being getting a graduate degree in Russian literature. It's just massive. There is so much of it, and of judges attempting to sort of yell from the rooftops that this needs to be fixed. And it's multiple levels of court. It's not just one or two judges. It's across sort of judicial personality and philosophy and so on. And it's not just one institution. It's not just Toronto South. It's not just Maplehurst. It is the definition of a systemic issue
and
in
sorry
Ontario.
here. The problem as
Yeah.
well is that it's not just the living conditions.
Right.
It's also in things that have to do with court efficiency. Like there are problems with the
Hmm.
jails, for example, in like bringing the inmate to his court appearance. There are often delays as well. There are often problems sometimes with their connection if they have to appear by video. So there's a lot of different levels of problems when it comes to the
Right.
jails, not just how they treat inmates inside the jails, but how they function even for court to get this person to a hearing, to appear before a judge because they have to be there. Even then, it seems like judges don't are getting sometimes frustrated because
Yes.
they have power, but it seems like jails, on the other hand, don't care. They're like, well, we don't have staff. Too bad. Like, what do you want us to do? Like, it seems like that's the attitude that we're getting from the jail when they're talking to judges. So,
Yeah. Well, and we're really talking about different, as you say, different
yeah,
levels of the same thing. There's the legal system and its attempt to function,
yeah.
the purpose of the legal system is to hold people accountable,
Mhm.
to care for and bring accountability to the interests of victims. And it cannot do those basic tasks because of what is happening in the jails. And it's
Right.
at the level of sort of everyday administration,
Yeah.
the ability to get folks to their Zoom rooms and
Yeah.
things like that. And it's at this very profound level of being unable to even continue with a prosecution
Right.
because of the misconduct of guards and abuses
Right.
and so on. So it's at multiple levels, but it is all about how the institutional
Hmm.
realities are disrupting the ability for the legal system to perform the functions assigned to it, right? And so was it 2 weeks ago, 10 days ago, when on one day we had this new legislation tabled that's going to make bail more restrictive. And then a couple days later, we had the stays in the Whitlock decision.
Yeah.
And I just found that to be like a striking week, right? That the federal government is thinking, let's add people to these remand facilities Let's grow that population. While in this province that has the largest of that population is sort of unable to function in the most basic
Right.
um,
Right.
ways. And, it's partly a function of our divided federalism when it comes to criminal law, that is even
Hmm.
possible, right? That we have a federal government that controls the substantive criminal law, and provincial governments that administer the jails, and that they're both kind of able to point at one another. And, the federal government can pursue its political goal of, looking like it's responding to concerns about bail. And it can do that without actually having to insist that the Ontario government step up to the plate and do the bare minimum when it comes to funding and operating the jails. And so at the very least, you did see the Justice Ministers, Sean Fraser, kind of say when he was doing media work around the bill being tabled, that this requires partnership, that these changes for them to be effective and for them to work do require the provincial governments to kind of do their part. But I think that it is incredibly naive to think that the Doug Ford government is kind of willing or able
Hmm.
to do its part to step up and improve the operations of the jails in this province, because we've had a decade of the crying from the rooftops from the judiciary, and substantial sentence reductions and all of that in many, many, many cases, and it has had no effect. So
Yeah.
now, if you don't mind
Yeah.
terribly, I was thinking of these themes in this discussion, and I was thinking of this. I'm just going to go full law professor on you for a moment, if you
No
don't mind.
problem.
But there's this wonderful book that I wanted to draw your attention to. It's called Contrasts and Tolerance.
Hmm.
And it's a comparative study between the UK and the Netherlands. And it's looking at sort of how, in the post-war period, the UK grew its prison system a lot. And the system got very tough on crime and a lot of the same kind of penal populism dynamics that we see today. Whereas the Netherlands was very moderate and very
Yeah.
consistent. And so it's a study sort of explaining like what's the difference and what's the same between these two systems? How do we explain these outcomes? It's a great, great book. It's published in 1988, but I find myself opening it all the time. And one of the most striking things in this book is that David Downs, the sociologist here, he's describing how the biggest difference between these two systems is prison overcrowding, that the UK winds up like with way more prisoners over
Hmm.
this time
Of
period,
course.
the
Yeah.
70s and 80s, than it is able to properly house,
Yeah.
right? And that this is the most striking difference between the two systems. And he says this, he says, the real contrast is between the principles underlying these ratios, these distinct ratios of prison places versus capacity. English prisons are obliged to accept immediately those remanded in or sentenced to custody by the courts. That's the system we have in Canada,
Yeah.
right? The jails or the prisons can't say,
Yeah.
no, thanks, we're full.
Right. Yeah.
They are obliged to accept whoever is remanded to them, and they have no choice over that. Dutch prisons are obliged not to accept those for whom a place is not available.
But the thing is, it makes
Yeah,
sense though. Like if you don't have, like if you want to book in a hotel, if they don't have space, no, sorry, I
right.
know. I mean, like obviously, it's not at all the same thing. But just to make the point here, if the hotel is full, they'll tell you, sorry, we don't have space. Like, what do you want us to do? And it's true. Like, why don't the jails say that? Because they probably don't have space, and
They
then
don't have space. I think
and then
we know that.
and then they
Yeah,
keep have to, and they have to, and that's why we hear three in a cell, four in a
right.
cell. It's because they don't have the capacity. So why, like, are they shy? Like, what is the issue? Why don't they say anything?
Yeah, I mean, I think that we know that, I mean, the three men in a cell for one is something that sentencing judges have in front of them every single day
Hmm.
right now, right, in
Yeah.
Ontario.
Yeah.
And oftentimes that's paired with extensive lockdowns,
Yeah.
right? So
Exactly.
it's an extraordinary
Yeah.
combination,
Yeah.
right, to do to people. So we know for sure there's nobody in our system who could doubt, like when it comes to the jails, we do not have capacity.
Hmm.
But we are going to add people. without any kind of conversation. And I mean, I'm not saying obviously the Dutch system, we'd have to have a big discussion about how it came to be that way and so on. And it's obviously a pipe dream to imagine that we would have that level of institutional, juridical kind of communication in Canada. But just notice, like, we have none. Right? The only kind of site of communication is at sentencing when we give these extraordinary sentence credits for the lockdown and the overcrowding and so on. That's the kind of only site of official
Well,
communication.
and what I noticed, Lisa,
Yeah,
is what the jails do is that if someone is sentenced or whatever, remanded, whatever reason brings that individual to the jail. So they will throw them in that institution. And then what happens is that they will start, if they're getting over capacity, they start shipping them to other far
yeah,
away jails, which causes even more problems. Like if that person still has a matter that's ongoing, because now instead of being in a jail in a jurisdiction that is typically close to where the lawyer is practicing, because most of the
right,
cases you're going to retain a lawyer in the area where the offense was committed. Then you have that inmate who's transferred, shipped to like sometimes 10 hours away from the lawyer because
right,
they don't have space. So it's just like creating all kinds of different problems, even
right.
for like just for that person to also communicate with their lawyers. So, I mean, I just find it like incredible, like how incredible, not in a positive way, but it just doesn't make sense. Like they're creating a system that doesn't function at all.
Well, and what's really interesting to add to this, I love the conversation we're having because
Hmm.
we're doing like practicing
Yeah.
lawyer.
Yeah.
We're weaving it
Yeah.
all together in a great way. So one of the upshots that Downs describes from the Dutch system is that judges got pretty reticent about using up a prison spot unless it was really called for.
Hmm.
Right, because for the someone who, really where incapacitation is very
Yeah.
much needed or whatever, they would want to make sure there was a space there. And so it kind of had the effect of creating this level of restraint,
Yeah.
right? And if we turn to Canada, it's always really striking to like review the data about how the vast majority of sentences, custodial sentences that are imposed in our courts every year are very short, right? About half of custodial sentences imposed each year are 1 month or less. 70% around are less than six months, and only 4% are going to federal custody, right? Only 4% of the custodial sentences imposed every year are people with longer than 2 years. And so the vast majority of our sentencing and our punishment, and the most common penalty, of course, is probation. So
Hmm.
it's mostly non-serious, at the non-serious end of the spectrum that we are just pouring in extraordinary resources.
Right.
And if we bring this all together and say, like, what would it look like if we did have more of a conversation about um, what is our institutional capacity and what kind of constraints should that be on lawmaking? Right now, that is completely
And
absent.
honestly, like really, and the issue here is as well, like about this point that sometimes most of the people that we have in the jails are the ones who have these short jail sentences. Like, do we really need to
Right.
send them to an institution? Like, we have conditional sentences. Like, why can't we just try to take more advantage of them or use other ways? Like, if it's less than, let's say, 2 years or maybe a 1 year or a few months, like, do we really need to put them in a detention center or in a prison or in a jail? Like, why can't we just do something else and just that sends this a strong message. And again, the Supreme Court in Senneville did say that there are other ways that you can still send a strong message without it being, like this jail. And a conditional sentence is one of these options as well that we have in our system. But again, we don't really fully take advantage of them. And that could also help the jails. Like we know that there is a problem with the jails and we're not helping the jails. We're just sending them more problems and more lockdowns. We're creating more lockdowns with every new inmate that we send and they don't have the capacity to bring into their institution. So it's really a hot mess.
It is a hot
Right?
mess. I think hot mess is the technical
Yeah.
term.
Yeah.
Yeah. Yeah.
I mean, I don't know like what is going on. But one other point that we were talking about before that I think maybe could help, but unfortunately we're not seeing more of that, is that there doesn't also seem to be a lot of public interest in this issue, the jail and the bail issue. I know for us practicing criminal lawyers, because it's a problem that we directly feel and we see that there's a crisis going on. Unfortunately, the public doesn't seem to be that much interested in this issue, and as a result, politicians are not don't want to waste too much time on this issue um, because maybe it's not very of much interest to the public. So maybe like what I'm trying to get at here, Lisa, is how can we really get the public to realize that this is important and there should be more public interest in this?
Yeah, it's always a tough question in this space. I think that we should just make all arguments straightforwardly on public safety grounds.
Hmm.
When we obviously you look at the Whitlock decision, this is a terrible outcome for public safety,
Hmm.
right? As the
Yeah.
judge knew, right?
Yeah.
The judge said the unthinkable has come to pass in
Yeah.
which, that stays in a murder prosecution. That one is plainly obvious. And and the blame for that should be laid at the feet of those the staff who participated in the way that they did.
Yeah.
And but if you even think about sort of less dramatic scenarios, day in and day out, there are sentence reductions made on the basis of sort of the Duncan Marshall
Hmm.
logic, where the result is that those who did time in remand, so did this very difficult, chaotic, onerous pretrial time, have far less time to serve as a sentenced prisoner because of the credits. They're getting their ordinary sort of summer's credit, and then they're getting oftentimes a big chunk of mitigating um, credit for really onerous conditions. And that is a bad correctional outcome, right? We want people to spend more time sentenced, where you don't have a correctional plan, you don't have any programming, you don't have any of that. You're not, and you're fighting for your life. Your trial's ongoing. You're not really in a rehabilitative moment at that part of the system, right? And so we don't want sentences to be devoured by credits at sentencing from a purely public safety. It's better for people to have a longer sentence ahead of them so that they can access programs and have time to think about what happened, right? Which is not something you do when you're going through your trial, right?
And I agree. I
Yeah.
totally agree. But I feel, and again, this is just maybe my personal view from how the public perceive that. Unfortunately, I sometimes feel like people will, uh, members of the public sometimes, they just want someone who's charged or accused of a very heinous crime to just be in jail. They don't care if it's pre-trial or pre-sentence custody. They just because you see from the comments, oh yeah, good, like good that they weren't released. These people don't deserve to be out, and so they should be there. And I find like it's the perception, unfortunately, that once a person is charged with an offense, right away there's this presumption of guilt, which is, as we've seen with the Zamir case, this is a perfect case of how the public perception changed. At the beginning, before he got to his trial, he was portrayed in the media as a monster, this guy, because he killed a cop. But then, as the trial started, and we were getting more information, the public perception really shifted in that case. And people were feeling really bad and sorry for him and for everything he had to go through. Yet at the beginning, when he was just merely charged, everybody was against this guy. And I find like this is another problem, misperception, is that when a person is charged with a criminal offense, to right away jump to the conclusion that he's evil, he's a monster, he deserves to be in jail, even if he's not sentenced yet. I think there has to be a change here on that level as well. The perception.
Yeah, and you've really talked about two different things there. One is sort of the guilty until proven
Yeah,
innocent idea.
yeah,
And that really just goes to, the essential function of defense lawyers in our society,
yeah,
that you fight against that. That's the work you do every day.
yeah,
to have the presumption of innocence be a real thing.
Yeah.
But then the second point is around sentencing. And there, I think you're alluding to a general sort of public attitude of just get them away from us.
Hmm.
I don't need to know if they're accessing programs or
Yeah.
not, right?
Yeah,
The point
exactly. They
is
don't care.
incapacitation.
Yeah.
Now, that's fine for you to kind of have that view. And I understand, and it's a normal thing to just want to be separated from someone who has harmed us. But unless and until we wind up, just giving everyone a life sentence for everything,
Yeah.
we do have to actually turn our mind to the fact of they are returning to us.
Hmm. At
And
some point,
at some
if
point,
they live long enough, of course. So,
right.
yeah.
And I mean, so about a quarter of the people in our federal prison population are there on indeterminate sentences.
Yeah.
So they're dangerous offenders or they're
Hmm.
serving life. And so there is a large, and that's sort of one big topic is
Yeah.
whether we're overdoing it in terms of punishment there and
Yeah.
making sure that they're all in their 80s before they have parole possibilities. That's one topic, but the rest of them are coming out.
Hmm.
And we have to ask, do we want them to come out at statutory release, or do we want them to come out in a structured program of parole where they are well supported and can integrate slowly? And I mean, these are not, you don't have to cast these as questions of prisoner rights. These are questions of public safety.
Right.
That we want people to return to us better. And we want them to return to us well, not more traumatized and not having no vocational skills and not having any idea how to open a bank account.
Right.
So, I mean, to me, I just see them as so interwoven. Like, I'm obviously a person who does care about prisoner rights. But even if that's just like not an area that, your kind of empathy capacity can really extend to, it's so intertwined with public safety, right? And I think that given the multi-billion-dollar investment that we are making in our federal prison system and then many more in provincial settings as well, that we should really expect a lot in terms of how people come back to us.
And
And right
yeah.
now, they don't come back with any education or vocational
No,
prospects.
and this is what also many of the inmates complain about is that they sometimes don't have the time to get into these programs. Like they want, many of them want to. They say that they want to get into programs, but they just there's like these waiting lists
Mm,
that they can't even be reached sometimes. They can't get into that. So you'll see the sentence is over and then they didn't have the opportunity to learn anything or to do anything constructive.
yeah.
So
Yeah, there's lots of problems with that.
right.
Lots of problems with
So,
that for sure.
I mean, okay, it just sounds very depressing right now. I know it's a crisis, but if there is something, and I don't want to take more of your time, Lisa, this was a very interesting, honestly, very fascinating conversation. We covered so many areas that are related to prison law, but I like to always end on a positive note. Is if
Okay,
there is anything
let's try.
positive, I mean, I'm gonna let you because so far, like, it just seems like it's all a hot mess, like we were saying. But if there is anything positive that we can talk about just to end this
Well, let me
conversation.
try. Let me try because
Yeah.
I did want to sneak this in a little bit. So,
Mhm.
so this isn't going to be uniformly positive. There's some very
Okay.
sad parts of
Of
this, but
course. Yeah.
but if we think back to the case of Adam Capet,
Hmm.
who you'll remember now Justice Mendane, she discovered him held in solitary when she was touring a facility up north. And he'd been held in solitary for something like 4 years with the lights
Yeah.
day. And there was a stay that was granted in his murder case as well. That was on the trial fairness grounds because the impact of segregation had been so extraordinary that they would have been unable to try the only issue in his case, which was his mental state. In the wake of the Adam Capet case, there was actually a real moment of awakening about solitary confinement.
Yeah.
And that was a long process. And our laws in Canada on solitary are better than what they were a decade ago. It is more structured. There's more awareness of the harm of isolation. And I think this goes deep inside even correctional staff and so on, that everybody understands more how harmful that is, that it's torture. And I think the jails and the prisons all do a better job on it. I really
Hmm.
do. There's still obviously significant issues.
Yeah.
But the case of Ashley Smith, the case of Adam Cappe, I do think that contributed to an awakening about the harm of segregation. The other thing that the Cappe case led to was in the final days of the Wynne government in Ontario, there was this effort to revise Ontario correctional legislation. And it led to the creation of the Ontario Correctional Services Transformation Act of 2018. And it's a good piece of legislation. It would improve healthcare. It would establish basic human rights and conditions of confinement rules. It would improve oversight and accountability, and it would enshrine in law some of these limits on segregation that, at least in Ontario, are really just common law. And so lots of important things in that legislation. And I do think if that bill came in, it would make things a lot better, and it would require investment on the part of the government as well.
Yeah.
Now, that act got royal assent in 2018, and the Doug Ford government came in and they have declined over all these years to implement the legislation. And so, we went to all this expense to draft this legislation. And the reason it was created, Howard Sapers was reminding me of this recently, that the reason it was created was because of the stays, or
Hmm.
the stay, I should say, in the Adam Cappe murder prosecution. That was a real recognition. That was very dysfunctional. We had that murder on video,
Yeah.
right? And it meant that the victim's family got no accountability in that
Hmm.
case.
Yeah.
Um, and so there was a sense at that moment in time that this is not acceptable.
Yeah.
And so we got this bill, and so my hope is just kind of remembering, like, we have made certain things better. Solitary is not as extreme and abusive and widespread as it used to be. And we know how to make better prison legislation that will improve conditions and working conditions for staff as well, so that they might be willing to come to work,
Yeah. That's
right?
another problem. That's
Huge
contributing to the
problem.
lockdowns as well, that we have a
Yeah.
shortage of staff. People don't want to work, or we don't have enough people. And that's also part of the problem. And like you said, that we have this potential, we have this legislation that could do good. But I
Yeah.
think what we need here is a push, maybe from the public, to put pressure on politicians to get these um, legislation into effect, and that we actually see them play out in real life, not just on paper. I mean, it's nice to have
Yeah.
good laws, but if we don't apply them, then what's the point of that
Well,
legislation?
and right now we don't have the laws on the books. That's the
Yeah.
problem. And
Yeah.
then we can turn to the task of
Yeah.
enforcing
Yeah.
enforcing the law.
Yeah.
But I'm sure once this podcast gets out there, that will be enough to change
Hopefully, I
the
mean,
public
like,
attitude.
well, I hope that we can help and that people will be interested. And I hope that it's not just lawyers or people who are in law, because it's a problem for everyone. And I don't know how exactly it was said, but I mean, the way, if you want to judge a society, you have to look at the way they treat their prisoners. And it's not looking very good right now. I mean, we know from our clients, we hear the horror stories, and we saw the horror stories at Maplehurst. Like the reason why it became a scandal is that we were seeing on video how, and of course, I understand that this is an isolated, well, I hope it's an isolated incident, that this is not something that happens on a regular basis in jails, like it was made just as punishment. But there are some horrible conditions in many of these jails, and inmates are always complaining about them, and people don't realize how bad it is until, unfortunately, a member of their family is there.
Hmm.
So I just hope that people will, like, the humanity will kick in, and that they will realize that it is a problem and that something needs to be done about that. Well, Lisa, I have to say that was a very, very interesting conversation. I really hope that we can have more talks about that as you write more about the subject, or another important case or incident happens. Hopefully, the next one will be a positive one and we'll have more positive news to talk about.
Thank you
So
so much. Happy to talk to you.
thank you very much.